Grounds for liability to pay damages. There are 4 grounds: fraud, negligence, delay, contravention of the tenor of the obligation. So, before we proceed with ano yung mga grounds, isa-isa mo, ano ba yung damages? What are really, ano ba ang damages? Damages, of course, refer to the harm done and the sum of money that may be recovered. Nasaktan mo, o ano ba yung pwede kong makuha dahil ako ay yung sinaktan? Okay? While on the other hand, para mas maintindihan nyo, kukumpara natin sa injury. Ang injury refers to the wrongful, unlawful, and tortious act. It is the illegal wrong to be redressed. Okay? Ito yung nakasakit ka. Okay? Pero yung harm, ano yung naging effect sa'yo? So, pwedeng bayaran ng pera yon. Injury, ano yan usually, unlawful. Damages, sometimes hindi naman unlawful. But you just have to pay for the harm done. Okay? There are 6 kinds of damages: actual, moral, temperate, liquidated, exemplary. Okay? Pag sinabi mo actual or compensatory, ito naman yung mga damages na nire-refer nito is pecuniary loss. Halimbawa, loss in business. Ito yung mga pwede mong ma-recover. Okay? It includes the value of the loss suffered and the profits not realized. Kung halimbawa ay... Oh, by the way, this is Article 2199. Halimbawa ng actual, usually nasagasaan. Hindi nakapagtrabaho ng 3 linggo. O di 3 linggo mong babayaran yung kanyang sweldo. So ito yung actual and compensatory damages. But when we speak of moral damages, they include physical suffering, mental anguish, fright, serious anxiety, besmirch reputation, wounded feelings, moral shock, social humiliation, and other similar injury, according to Article 22:17 of the New Civil Code. O ano yun? Ito naman, usually, binibigay ito ng korte kasi depende yan sa mga naranasan mo. May standard yan. Halimbawa, na-rape or nakapatay. Alam ko nung unang panahon, pag na-rape or nakapatay, ang binabayad sa pamilya 50,000 pesos. I just don't know now kung magkano na yung amount. Kasi ito yung mga sleepless nights. Halimbawa, isa sa mga nangyayari rito is pag yung mga artista, chinichismis, tapos nagre-reklamo sila, halimbawa, demanda nila ng libel, tapos 1 million moral damages. O bakit? Kasi hindi raw sila makatulog. Diba? Mental anguish. Sumasakit nasi-stress sila. Physical stress suffering, sakit na yung balat nila, sa kakaisip nila ng problema dahil inaapi sila. Anxiety attack. O tapos, lalo na kung sabihin na, ay, ang babaeng yan, dating kung ano man. Diba? Ang artista. O, that is besmirch reputation. Pwede kang mag-charge ng moral damages. Now, what is nominal? Ito naman yung mga damages to vindicate a right. Siyempre, dahil nagkamali, may ginawa kang mali, ay, kingi ako ng nominal damages kasi kailangan itama yung pagkakamali mo. Magkano yon? Depende yan sa nagre-reklamo. Temperate or moderate damages, they are more than nominal but less than compensatory, but may be recovered if the court finds that some pecuniary loss has been suffered, but its amount cannot from the nature of the case be proved with certainty. O, sinasabi dito, hindi naman, they are more than nominal, o, to vindicate a wrong, pero hindi naman ganun kalaki para dun sa pecuniary. It's more of in between. Okay? Moderate damages, pwede ka ring humingi niyan. Okay? So, depende yan sa nature ng kaso nyo, kung pwede mo siyang hingin. Liquidated damages, those agreed upon by the parties to a contract to be paid in case of breach. Liquidated, na pag-usapan natin, ito babayaran mo pag nag-breach ka. Bayaran mo ko ng 50,000 pag hindi mo tinupad ang usapan natin. Ang tawag doon, liquidated damages. O ano naman yung number 6, exemplary or corrective. These are imposed by way of example or correction for public good. In addition to the moral, temperate, liquidated, or compensatory, binibigay ang exemplary or corrective. That is Article 2229 of the new Civil Code. Tutuloy ko lang, okay? Ano ba yung proof ng pecuniary loss? There should be a proof. Tandaan nyo parate, nire-require ang proof pag actual or compensatory. Okay? O ano pa? Pero pag yung mga other damages, hindi naman kailangan. Siyempre, basta nasaktan ka lang, i-ano mo lang doon, i-stipulate mo lang yung nararamdaman mo noong mga panahon na yun. Okay? These are the 6 kinds of damages. Now we go to of course, yung grounds talaga para ikaw ay makahingi ng damages. Grounds to pay damages. What is the concept of fraud? Fraud is the deliberate or intentional evasion by the debtor of the normal compliance of his obligation. Ulitin ko ha. Fraud is the deliberate or intentional evasion by the debtor of the normal compliance of his obligation. Talagang deliberate or intentional. Iniwasan mo. Okay? Yung dapat mong gawin. At ang ano mo, naisip mo, talagang manloko lang. Okay? This actually refers to the fraud committed by debtor at the time of the performance of the obligation. Sa time na magpe-perform siya ng obligation, dun niya ginawa yung kanyang fraud. Siyempre, bago natin matuloy ito, kailangan, ano muna yung mga different kinds of fraud para mas madali yung maintindihan. Technically speaking, ang fraud natin is, according to meaning, meron tayong tinatawag na fraud in obtaining consent. Okay? Kasi di ba? Nanloko ka para pumasok ang isang tao sa isang obligasyon. Kailangan mo makuha yung consent niya. So ano yun? Meron tayong tinatawag na causal fraud or dolo causante. Meron din tayong incidental fraud or dolo incidente. And yung tinatawag naman natin na fraud in the performance of an obligation. Ano naman doon is, yung isa pa is according to the time of commission. Okay, explain ko muna isa-isa ulit. Fraud in obtaining consent. Ito yung pinaka-importante. Para makuha mo yung konsente, ito yung tinatawag nating causal fraud. Okay? This refers to the fraud without which consent could not have been given. It renders the contract voidable. Kung wala itong fraud na to, hindi dapat magkukonsente ang isang tao na pumasok. Example na lang. Sige. Halimbawa, si boy bought a ring from this girl, si Susie na lang. Bumili si boy ng ring kay Susie. Sabi, who told him that the ring was embellished with diamond. Okay? Sabi ni Susie, ang ganda nitong sing-sing na to. Diamante to. Pero sa totoo lang, however, Susie knew along that the embellishment was not diamond, pero puwet lang ng baso. Okay? Hindi siya diamante, kundi puwet lang ng baso. So, si boy here gave his consent because of the fraud employed by Susie. Hence, the contract is voidable. Causal fraud. Okay? Sa example na yon, dahil sinabi ni Susie na hindi, diamante to. This is a diamond. So, ano to? Dapat, pwede mong bilhin. Yung pala puwet lang ng baso. So, naloko. So, ang tawag doon is causal fraud. Kasi kung wala yung panloloko na, hindi naman niya bibigay. Hindi naman siya bibili. Now, what is incidental fraud or dolo incidente? This refers to the fraud without which consent would have been given still, but the person giving it would have agreed on different terms. Okay? kahit meron o walang fraud, yung consent makukuha niya pa rin. Pero, syempre may mga pagbabago. So, ano yung mga style na ganon? This one muna, the contract is valid but the party employing it shall be liable for damages. Example, si Kaloy hired Darwin to teach in school of Kaloy. Okay? Si Darwin, nilagay niya sa application niya that he already earned MBA. However, Darwin had actually dropped the subjects for the said units. So si Darwin wala naman palang MBA. So sabi ni Kaloy, I will hire you kahit na wala kang MBA. Pero mas mababa ang salary mo. Kasi hindi ka naman MBA. Kung may MBA ka, mas mataas ang salary mo. Kaso niloloko mo ko. So the contract may be valid, but Kaloy, as the owner of the school, may ask for damages and even lessen the salary that has been agreed upon. Okay? Fraud in the performance of the obligation. This is the deliberate act of evading fulfillment of an obligation in a normal manner. This presupposes an existing obligation. Hence, the fraud has no effect on the validity of the contract since it was employed after perfection. However, the party employing it shall be liable for damages. I repeat, this is Article 1170 of the New Civil Code. This is the deliberate act of evading fulfillment of an obligation in a normal manner. Okay, merong existing obligation, so deliberate yung pag-iwas. Hence, the fraud has no effect on the validity of the contract since it was employed after perfection. So, ibig sabihin, may kontrata na, may usapan na, may agreement na. So, ngayon, nung magpa-perform na, iniwasan niya. So, that is according to fraud in the performance of an obligation. Example, si Badong ordered 10 bags of powdered soap from Sally, who agreed to deliver after 2 days. On the due date, Sally delivered 10 bags of powder soap na hinaluan niya ng chalk. So, this is fraud in the performance of an obligation. Now, Badong is entitled to recover damages. The fraud, however, does not have any effect on the validity of the contract. Valid yung contract, syempre. Dahil na pag-usapan nila, nanloko lang isa dun sa pag-perform ng obligation. Okay. Kung nyo, there is a contract, there is an agreement. Pero nung implementation na ng agreement, nanloko na si Sally. So, imbis na powder soap yung dinala, nilagyan niya ng chalk. Okay? So, ang remedy ni creditor doon sa ating previous topic is that to compel to deliver and pay damages. Okay? Next. According to time of commission, ito yung meron tayong tinatawag ditong future fraud and past fraud. Future fraud, a waiver of an action for future fraud cannot be made. If there is an agreement for its waiver, the same is void. Hindi kayo pwedeng sabihin na, lolokohin kita in the future. Hindi pa pwede yun. That is clearly a void statement. Thus, the debtor will still be liable for damages if he commits fraud in the performance of his obligation despite the waiver. Kasi future fraud cannot be made. Okay? Magbabayad ka pa rin ng damages. Past fraud, a waiver of an action for past fraud may be made since the commission of fraud can no longer be encouraged. Such waiver is an act of liberality on the part of creditor. Siyempre, pag tapos na, wala na tayong magagawa. Pero, of course, nasa creditor na yon. It's up to the creditor if he is going to hold the debtor liable for damages. Okay? Now, we move to negligence. Ano bang concept ng negligence? It is the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time, and of the place. Okay, 1173. I will explain. Ulitin ko muna. It is the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time, and of the place. Ito yung failure to observe for the protection of the interest of another person. Okay? Failure to observe. That degree of care, precaution, and vigilance which the circumstances justly demand, whereby such other person suffers injury. Kasi, negligent ka. Ibig sabihin, iniwasan mo yung dapat na pag-iingat na ginawa mo. Okay? Na nire-require ng batas sa'yo. Dapat pag ikaw ay nagda-drive, hindi ka umiinom, o pag nakasagasa ka, negligent ka na. Because you failed to observe for the protection of the interest of another person. Di nakabangga ka. Ang degree of care mo nga doon, usapan is extraordinary. Okay? So, paano ngayon natin to ipapakita? Siyempre, of course, para mas maintindihan nyo, the test of negligence is whether the defendant in doing the alleged negligent act used that reasonable care and caution which an ordinary person would have used in the same situation. Ang pinaka-test of negligence, kung dalawang tao, yung isa nag-iingat, yung isa hindi. Paano ba nag-iingat to? Para tingnan yung pag-iingat na ginawa. Ang pinaka-test doon, ano ba ang pag-iingat na gagawin mo? Kung ang pag-iingat na gagawin niya ay hindi pareho doon sa dapat na pag-iingat din, that is the test of negligence. If the law or contract does not state the diligence which is to be observed in the performance of the obligation, anong standard of care? The debtor must observe the diligence of a good father of a family. Okay? Example, if the obligation is to deliver a specific, kunyari, window glass, the debtor must ensure that the glass, considering its fragility, okay, yung kanyang fragility is well protected when he transport it as required by the nature of the obligation. Otherwise, negligent siya. Dapat balutin niya yung salamin. Hindi pa pwedeng basta-basta niya nalang kinarga yun. Gaya nga ng example kong cake. Dapat yung cake, sinabi ng Grab, dapat ayusin ang pagbitbit. Hindi pa pwedeng basta-basta niya nalang ibabagsak doon dahil dapat ingatan ng cake. Diba? Dapat pagbuhat pa lang, makikita mo na yung ayos. Otherwise, he will be negligent. There are three kinds of negligence or culpa. The culpa contractual or contractual negligence. Ito yung negligence na in the performance of a contract, such as the negligence committed by the driver of a bus when a passenger is hurt during the trip because there is a breach of contract of courage. Di ba yung mga ticket nyo sa bus? Yun, kontrata yun. Kasi nagbayad ka, binigyan kang ticket, dapat makarating ka sa patutunguhan mo. Pag hindi ka nakarating sa patutunguhan mo, that is already considered breach of contract of carriage. Okay? And again, sa bus, ito yung tinatawag nating extraordinary diligence. Kasi may contract kayo, dapat mag-ingat sila. Okay, bibigyan ko kayo ng isang case. Di ba sabi ko sa inyo, para mas maintindihan nyo, yung pagbabasa ng cases are important. In the case of Saludaga versus Far Eastern University, April 30, 2008, GR number 179337. Si student ng ex-university ay nabaril at ng isang gwardya. Okay? So, si student dinimanda si ex-university for damages on the ground that it breached its obligation under the contract of enrollment. Okay? Basta kayo doon, impliedly, dapat ang mga estudyante ay na safe and secure ang environment, lalong-lalo na sa eskwelahan because the atmosphere in the school should be conducive for learning. Ang ginawa ni university in his defense, sabi niya, hindi namin kasalanan yan because hindi naman namin maiiwasan o na itong mga taong to, aksidente na ginawa ng gwardiya, and saka hindi namin sila empleyado kasi di ba uso sa mga gwardiya, mga third party or manpower. So, ito yung tinatawag natin, sabi ng school, is fortuitous event. Okay? At ano naman kumbaga sa we try to ensure a safe environment for its students by having exercised due diligence in selecting the security services of the isang agency. Ano sabi ng Supreme Court? Sabi ng Supreme Court, the respondent school is liable for damages for breach of contract due to negligence in providing a safe learning environment. It is settled that in culpa contractual, the mere proof of the existence of the contract and the failure of its compliance justify a prima facie corresponding right of relief. May nangyari, may disgrasya, obvious na. Meron na kagad breach of contract yung eskwelahan dahil may nangyari. The school failed to prove that it undertook steps to ascertain that the security guards assigned to it actually possessed the required qualifications. A learning institution should not be allowed to completely relinquish security matters in its premises to the security agency it hired. To do so would result in contracting away its inherent obligation to ensure a safe learning environment for its students. The defense of fortuitous event or force majeure must also fail. An act of God cannot be invoked to protect a person who has failed to take steps to forestall the possible adverse consequences of the loss sustained. Okay? So, may nangyari, hindi mo pinatunayan na yung mga guards mo ay nag-exercise ka, dapat chine-check mo, mental, physical, everything shall be considered. Kung hindi mo ginawa yan, then there is a total breach of contract in terms of school and student relationship. The fact na nag-enroll sa yan, aalagaan mo yan hanggang sa makalabas ng eskwelahan. Okay? Now, what is culpa achilliana? Culpa achilliana is the civil negligence or tort or quasi-delict or culpa extra-contractual. Okay? So, wala namang contract. These are acts or omissions that cause damage to another, there being no contractual relation between the party. That is Article 2176 of the New Civil Code. Okay? The master-servant rule, hindi nag-a-apply dito. Okay? Ito yung nag-a-apply. Kasi, dahil yung master-servant, meron yung contract. Yung driver-passenger, may contract yan. So, ano yung hindi mag-a-apply dito? Halimbawa, yung pedestrian. Pedestrian na sa kasaan ng driver, wala namang kontrata yung pedestrian. Yung tumatawid, wala silang kontrata. So this time, the driver is liable for damages based on culpa achilliana. Dahil walang contract or bumangga yung driver sa bahay, nasira, wala namang kontrata, pero may nasira. So that is culpa achilliana. Tandaan nyo walang kontrata between the driver and the person na damage. So, pwedeng pedestrian, pwedeng bahay. What is the last one? The last one is, it is culpa criminal. Letter C is culpa criminal. I repeat, typo error, letter C is culpa criminal. When we speak of culpa criminal, this is the negligence that results in the commission of a crime. Defense of a good father of a family is not a proper because the employee's guilt is automatically the employer's guilt if the former is insolvent. Ano ibig sabihin nun? Okay. By example, para mas maintindihan nyo, the passenger of the bus may bring a court action not only for culpa contractual against the bus owner, but also for culpa criminal against the bus driver for physical injuries through reckless imprudence. In the same way, the pedestrian may bring not only suit for culpa quiliana against the driver and the owner, but also culpa criminal against the bus driver for physical injuries through reckless imprudence. Kanina may contract, yung isa walang contract. Ito wala naman siyang contract, pero may krimen na nangyari. Kaya siya culpa criminal. Okay? Kaya siya culpa criminal. Next, delay or default or mora. What is the concept of delay? Delay, default, or mora is the non-fulfillment of an obligation with respect of time. Kaya pinag-uusapan dito, time. Merong time concept. Okay, ano ibig sabihin nun? Anong different kinds para mas maintindihan nyo? Mora solvendi, delay on the part of the debtor. Extra, delay in real obligation, obligation to give. Ibig sabihin na delay yung pagbigay mo. Extra ang tawag doon, delay in real obligation. Okay? Ano pa yung isang klase ng mora solvendi? Ex persona, delay in personal obligations. Diba? Obligation to do. Nagkaroon ng delay sa paggawa. So, mora solvendi is delay on the part of the debtor. Mora accipiendi, it is the delay on the part of the creditor. Ito yung mga nag-exist when the creditor refuses to accept the thing due without justifiable reason. Ayaw tanggapin eh. Ayaw lang tanggapin. Walang dahilan. Basta ayaw tanggapin. But when we speak of compensation more, delay and reciprocal obligation, pareho na silang may delay. Both the debtor and the creditor. Then both parties are in default. Here, it is as if there is no delay. Siyempre, parang walang delay. Parang, delayed ka, delayed ako, walang delay. Ganun lang kasimple. Okay? When the debtor incurs in delay in obligation to give, to do, ano yung mga requisites? Okay? When debtor incurs in delay in obligations to give or to do, what are the requisites? The general rule, the debtor incurs in delay from the time, ulitin ko ha, from the time the creditor demands fulfillment of the obligation. But the debtor fails to comply with such demand, dapat the debtor does not perform his obligation, the date is due, the creditor demands the performance of the obligation, and the debtor does not comply with creditor's demand. Okay? No demand, no delay as a rule. Dapat mag-demand. Sample, si debtor owes creditor 5,000. The obligation is due on May 15. If debtor does not pay on May 15, he is not yet delayed. But if C makes a demand on him to pay on that date and thereafter, D does not comply, then D will be in delay. Okay? Sir, paano yun? Kailangan ba parati may demand? Hindi naman. Kasi meron tayong tinatawag na exceptions. Ano yung mga exceptions? Delay will exist even without demand in the following cases. This is Article 1169 of the New Civil Code. Number 1, when the law so provides. Sabi ng batas eh. Alam naman kumontra ka, sinabi na nga ng batas na walang delay. Number 2, when the obligation expressly so declares. Talagang kailangan mo magbayad kasi ng obligasyon mo. So wala nang demand na kailangan. Number 3, when the time of the essence of a contract is important. Siyempre, alam na mag-demand pa ako kaya nga kita inobliga because time is of an essence. When the demand will be useless. Number 4, useless na yung demand kasi tapos na. And then in reciprocal obligation, where the obligations arise out of the same cause and must be fulfilled at the same time, the moment one of the parties fulfills obligation, delay by the other begins notwithstanding the absence of demand. Yung kayo na example ha, isa-isa. When the law so provides, thus where the law provides for the payment of penalty if the obligation is not performed on due date. Aba, hindi na kailangan. Bakit pa kailangan yun? Meron ng penalty sa bawat delay mo. So, obvious na. Gaya ng pagbayad ng taxes. Hindi ka na kailangan singilin pa ng BIR. para masabing delay ka. Magbabayad ka ng penalty pag hindi ka nagbayad. Okay? When the obligation expressly so declares, number 2, hence no demand is necessary if the lease contract provides that the rental shall be paid by the lessee within first 5 days of the month in advance without need of demand. O yan, nakasulat na mismo. Without need of demand. Magbabayad ka sa first 5 days. That is, the obligation expressly declares. When time is of an essence, bawa, nag-usap kayo, May 15, magre-rent ako sa'yo ng kotse, gagamitin sa kasal. Kailangan pa bang i-demand sa'yo na mag-deliver ka ng rent-a-car kung ang kasal ay May 15? Wala na. After May 15, tapos na ang kasal. Hindi ko na kailangan ng kotse. Ba't ko pa kakailanganin? May 15 ang kasal. So, that is time is of the essence ng kontrata. Number 4, demand will be useless. The debtor will be in delay even without demand from the creditor if the thing he is obliged to deliver has been destroyed through his fault or he has delivered it to another person. No need for demand. Deliver ka ng bahay, nasunog yung bahay. Paano pa ako magdidemand? Nasunog na yung bahay. Or, kailangan ko pa ba mag-demand? Na-deliver mo na sa iba yung kotse. Obvious ba? Bigay mo na sa akin. Magbigay ka ng bayad ka na. No need for demand. Kasi, alam naman bawiin ko pa yun doon, binigay mo na. Okay? That is, hindi mo na kailangan mag-demand for the delay or default or mora. Kung yung reciprocal obligations, yung obligation, pareho naman tayo. Pero ako ready na akong gawin. Hindi ko na kailangan mag-demand. Kasi nagawa ko na yung part ko. Ikaw naman ang gumawa ng part mo. Okay? So what is the effect of delay? The debtor shall be liable for payment of damages. If the obligation consists in the delivery of the terminating, he shall be responsible for any fortuitous event until he has effected the delivery. Ito yung sinasabi natin, di ba? Sabi natin, extinguish ang obligation pagdating sa fortuitous event. Ibig sabihin, kung ang obligation ko ay mag-deliver ng kotse, kaso lumindol, nahulog yung kotse sa fortuitous event, talaga namang i-deliver ko sa'yo, on the way na ako. Well, I'm not liable, extinguish na yun. Pero kung dapat ang delivery ko kahapon, ngayon nahulog, ngayon naglindol, ngayon nawala, I am responsible. Okay? And therefore, I am liable to pay damages. And that is delay or default or mora. O ngayon, ano naman ang fortuitous event para mas maintindihan natin? The concept of fortuitous event are those events that could not be foreseen or which, though foreseen, are inevitable. Hindi mo siya nakikita, pero kahit na nakikita mo siya, hindi mo mapigilan. Alam natin may bagyo. Parating ang bagyo, pero hindi natin alam kung gaano kalakas. So, inevitable siya. It is not enough that the event should not be foreseen or anticipated, but must be impossible to foresee or avoid. Imposible mong makita. Yun yung mga mga rally, di naman yan. Kasi rally, sabi nila dati, na-traffic ako kasi may rally. Hindi. Alam mo, dapat na may rally. Kasi obligasyon mo mag-deliver. Dapat ready ka, dapat nanonood ka ng news. So, rally is never an excuse or never a fortuitous event. Examples of a fortuitous event, natural calamities or acts of God, such as earthquake, typhoon, and lightning, and acts of man, such as war and armed robbery. O ngayon may kasama na pandemic. Okay? Pandemic. Elements, para mas may breakdown natin yung meaning ng fortuitous event. Ano yung mga elements? The cause must be independent of the debtor's will. Okay, yung mga requisites. Dapat, hindi dapat. Okay, independent of debtor's human will. Hindi dapat meron ka siyang sangkot. Sinabi niya may gera, yung pala siya may gawa ng gera. Could not be foreseen. If foreseen, it is inevitable. Okay? There is an impossibility of seeing things. Impossibility to comply. Next. The debtor must be free from participation or no current negligence. Okay? So what is the general rule? No person shall be liable for fortuitous events. His obligation will be extinguished, except Article 1174. Exception to the rule. Okay? General rule, extinguish ang obligation, pero kung ang fortuitous event ay nag-occur, so, yun ang exception mo. Okay? What else? Pero kung napag-usapan nyo, when the law expressly provides for liability even in case of fortuitous event, well, that's another exception. Or, when the parties have declared liability even in case of fortuitous event. Remember, ang usapan ng both parties are force of law between the parties. So, kung meron silang agreement, kahit na merong fortuitous event, liable pa rin. Kasi general rule na may sinasabi nating extinguish ang obligation. And when the nature of the obligation requires the assumption of risk, such as obligation of the insurer who must pay the policyholder even if the loss is caused by a fortuitous event. The case thereof is the risk insured against. Okay, yun yung mga nasa insurance. Talagang ano sila, no choice. Kung namatay dahil sa fortuitous event, magbayad sila. They should pay. Okay? Ano pa? Ano pa ang ating... Of course, there are two kinds. Two kinds of fortuitous event. Ano ba yung two kinds? The ordinary and the extraordinary. Yan yung mga difference lang naman ng ating fortuitous event. Ano ba yung ordinary? Events which are common, which are contracting, should reasonably foresee. Gaya ng rain. Pero extraordinary, ito yung mga events which are uncommon and which the contracting parties could not have reasonably foreseen. Like earthquake, fire, war, pestilence, and unusual flood. Okay? Unusual flood. Ano pa? Well, acts of man, acts of God. Ano yung mga acts of man? War, fire, robbery, murder, insurrection. Acts of God, earthquake, flood, rain, shipwreck, lightning, eruption of volcano. Yan yung mga acts of man and acts of God. Okay? Rules as to liability in case of fortuitous event. Nasabi ko na kanina, when expressly specified by law, exceptions, debtor guilty of fraud, negligence, or delay, or contravention of tenor of the obligation. The debtor has promised to deliver the same thing to two or more. Obligation to deliver a specific thing arises from a crime. And the thing delivered is a generic thing. Okay? When declared by stipulations, when the nature of the obligation requires the assumption of risk. And yung mga rules as to liability in case of fortuitous event. Now, important theories to remember. Ownership, sabi ko nga, pinramis ko sa inyo kanina. Ano yung mga tinatawag nating delivery? Ano yung mga klase ng delivery natin? Okay? Ito yung sinasabi ko, ang delivery ng susi is already considered as a delivery. Pag may susi ka, dineliveran ka, o iba ibig sabihin nun, it's either sa'yo na yung kotse o sa'yo na yung bahay. Kasi susi na yun eh. Susi na ang pinag-uusapan natin doon. So doon pa lang is already a real right against the whole world. Okay? Tawag dito usually ay tradisyon. So, siyempre, in sale, for example, a mere agreement on terms thereof does not affect the transfer of the thing sold in the absence of delivery. Actual or constructing delivery of the thing, pwede na. Okay? So, yan yun. Yan yung pinaka-important theories. Ano yung performance by third person? Importante yan. In a performance by a third person, The personal obligation to do, like real obligation to deliver a generic thing, can be performed by a third person. Pwede. Hindi ibig sabihin one-on-one lang. Merong ibang tao na, oh sige, ibang magde-deliver sa'yo. Iba ang maghahatid ng utang ko kasi may utang siya sa akin. That is considered performance by a third person. While the debtor can be compelled to make the delivery of a specific thing, a specific performance cannot be ordered in a personal obligation to do because this may amount to involuntary servitude, which as a rule is prohibited under our Constitution. Ito ang pinag-uusapan natin dito, performance of a thing to do. O, halimbawa, A, tapos pinapatrabaho niya yung karpenterong B, pinipwersa niya magtrabaho, hindi pa pwede yun. So what he can do sa KA is talk to a third person, ikaw ang magtrabaho, gawin mo yung karpentero, sisingilin ko to, siya magbabayad kasi bayad na siya. Okay? That is performance by a third person to do. Any questions? Just ask me. Private message me. Prepare for your prelim exam next week. Thank you. God bless.